we initiate chaos. Theory guarantees that we'll play like lightning shots, sounding like thunder. For every time in the face that it hits us, we're faster. Well, they should know by now. They see the world keeps trying to shake us. It only wakes us. The pendulum swings. The pendulum swings. It's in a beautiful darkness. Only another. It's full steam ahead. Full steam ahead. All about the Petty Express. Misdirected from the start. It's a runaway train. I come a freight train. I come a freight train. In a beautiful darkness, the Petty Express. In a beautiful darkness. Hey guys, it's your conductress on the Petty Express Mo, and I do have my emotional support, Coke Zero, but this Petty Express tour is going to be Shanda Vander Ark requesting a new trial. Now, if you're not aware of Shanda Vander Ark, I do have a couple articles to kind of give you a little bit of a too long didn't read kind of background on that. This is a mother who took the life of her autistic son. So this is not an easy case. It was heartbreaking. She is a total monster, and I will read her as such for this entire stream. But the mother who took the life of her son claimed that she was in a catatonic state during her trial. Now, this is a woman who has not only a law degree, graduated summa cum laude, I think, second in her class in law school, and basically aced the LSATs. So this is not a stupid woman, although you almost wish she was stupid, because the fact that she's so intelligent means that she planned the systematic taking of her son's life in sadistic and torturous ways. Shanda Vander Ark, the woman convicted of taking the life of her teen son, is asking for a new trial in one of Muskegon County's most horrific child cases. The request comes nearly 3 years after 15-year-old Timothy Ferguson was found unresponsive in his home. He had already passed away, but basically he was 67 pounds at 15 years old. And welcome, Emerampure. I am on the green machine if you do not want to hang out on YouTube. Now, I will give you guys the heads up that the judge saw through this and said, no, you're not getting a new trial on any of the spurious stuff she brings up in this hearing, but he is allowing her to refile for a new trial under different legal bases. Now, Vander Ark, 46, is serving a life sentence at the Women's Huron Valley Correctional Facility on an open murder charge for Timothy's murder. Her appeal to the state's Court of Appeals is pending, so we might get an appellate case regardless, but this is more her going to the trial judge and saying, I was out of my mind. And we all believe, yes, you are out of your mind, but you were able to testify. Now, Timothy suffered just unimaginably. And basically between his mother and his brother, Paul, was systematically, kept away from food, given physical punishments like running up and down the stairs. And because of Timothy's disabilities, he was not coordinated. So there would even be, Paul would have to chase him. It's a horrific case. Alternate Juror did a really good job covering this if you want to go see this trial, but it is an absolute heartbreaking case. Timothy weighed 69 pounds when he was found no longer living on July 6, 2022, in the family's North Shorten home. Now, Vander Ark was arrested that morning and charged with open murder and, child grossness. Now, she was deemed competent to stand trial about 5 months after Timothy's death. And during the week-long trial, the jury heard, and not only that, Shanda Vander Ark testified in her own defense. So I don't know how you can be not competent and testifying, but I'm not a doctorologist. Now, Vander Ark was sentenced in January 2024 to life in prison without the possibility of parole for Timothy's murder. She was also sentenced to an additional 50 to 100 years for all of the torture she put Timothy through. Now, Vander Ark is claiming, and this is what this hearing we're going to watch, she claims that she is not competent, or she wasn't competent to help with her defense in the first trial. Now, she's not competent because she lacks a soul, and I don't know how humans survive without one. Now, since she was arguing that she was not competent, they do have to have a hearing, and that is what we're going to watch. But rest serenely that the judge said, yeah, no. But we get to listen to her babble, I'm sure. Pray for me for now and at the hour of this see you next Tuesday saying something. I do have closed captions on and the sound boosted, so let's hope their audio is working and they're not afraid of the microphone. And hello, Jason J. and Tammy Fayette. I agree. I did do a video when this news first came out, and if you can't handle the whole trial, and I would recommend that you listen to the victim impact statements of Timothy's brother and sister left behind. They're incredibly beautiful and just absolutely both heartbreaking, but also you get to learn a bit more about Timothy and who he was as a kid and how loved he was. Ooh, setting up the mics, setting up the mics. Come on now. This might not be a very long one, but I mean, who really wants to listen to her babble? And this might work out because we are in the middle of like storm central this week. I don't know. We have rain for. Alrighty. Does anyone show up? Oh, here we go. Finally.
Good morning. One second, hold this in.
I don't believe this is the same judge she had for the trial. Ah, you still look like a swamp monster. Hag demon.
Okay. Before the court is file 23110FC. It's People State of Michigan versus Shanda Vander Ark. Are you Shanda Vander Ark?
Yes.
All right, Mr. Vander Ark, Miss Vander Ark, can you hear and understand me okay?
Yes, I can.
All right. Ms. Vander Ark, we had confirmed through your counsel that you wish to appear at this hearing via Zoom today. Is that still your desire?
For this hearing.
For this hearing. Okay. All right. Mr. Ambrose is here on behalf of the defendant, Ms. Vander Ark. Mr. Roberts, as well as Ms. Bloomquist, is here on behalf of the people of the state of Michigan. State and time scheduled for a hearing on plaintiff's motion for a new trial or evidentiary hearing. Or excuse me, defendant appellant's motion for a new trial or evidentiary hearing. The court has read the motion, the attached brief, as well as the plaintiff's response and brief in opposition to that.
Living life with FND, I'm going to say one you don't mind scrubbing paint out of. Maybe not your favoritist. And welcome, John.
evidentiary hearing, including the attachments. Was there anything else that was submitted, either Mr. Ambrose or Ms. Bloomquist, that I don't have at this time?
I have not submitted anything.
Okay, Ms. Bloomquist?
No, Your Honor.
Okay, Mr. Ambrose, at this point in time, you want to just make some argument? You can call witnesses. I'll leave it to you at this point.
If testimony is going to be taken, I would prefer that I have my client with me in person. That's our preference in this type of setting. Typically, on a motion like this, if the court grants any type of evidentiary hearing, that would be great, and then we could have Ms. Vander Ark in person with us.
Okay.
But other than that, I did write a pretty detailed brief in this case, raising two primary issues. One is whether or not Ms. Vander Ark was competent after giving her first day of testimony. She had a medical issue. She was in some sort of distress. Coming back the next day, it seemed pretty, from the transcript at least, that she had undergone a significant downturn in her mental health. That it was described by her trial counsel that she was not competent to go forward. I think there was about a 2-hour delay. There was some sort of discussion with Ms. Vander Ark. There was a report that she may have wanted to hurt herself. All of these factors are pretty consistent.
I don't care. Like, I mean, maybe it's just me, but I don't care that Lori had a UTI. I don't care that Shanda was feeling a little sad and down. You're adjudicated murderesses. I really don't care if you've got a boo-boo or a tummy ache. And this is such a weak argument. Again, who in prison is having a great time? It's supposed to be a punishment. I don't care if your feelings were hurt.
Consistent with the case that I cited, seminal cases, Droke versus Missouri. And if you look at that case and Ms. Vander Ark's situation, they pretty much fall in line. So, if the bottom line is, was there a bona fide doubt as to her competence? And if there was, then the way to go about things is suspend the trial, have her checked out, and then if there is no longer an issue there, then proceed with the trial. And that's consistent with what Droke says, but it wasn't done in this case. And if there is additional testimony taken on this issue alone, like I said, I would like to have Ms. Vander Ark here for that. The second issue, Your Honor, is ineffective assistance of counsel. I laid out a number of areas that I feel that there were some missteps in that Ms. Vander Ark was not provided her Sixth Amendment right to the effective assistance of counsel. And we do start off again.
Well, I mean, her lawyer kind of sucked. I'm trying to pull to give you kind of a flavor of Shanda. I am pulling her testifying. So we will go over that next because this isn't going to be a super long hearing. But he counts as a lawyer. Sarah Boone's lawyer counts as a lawyer. The fact that they're terrible at their jobs or terrible with their client is not anyone else's problem. And Jedi Jess says, short version, after she testified and was cross-examined, she claimed she had a mental breakdown and couldn't aid the remainder of her case. But she was the only person to testify for the defense, so she was basically the defense because her defense was, according to her, and you'll hear her tell it as she testifies on direct next. I was a poor mother who had 3 children at home and a sick husband, and I just couldn't, function and remember stuff. So just, Well, Lori hired herself. And when they say when you hire yourself or when you take yourself as your own lawyer, you have a fool for a client. That being said, I don't know that any lawyer would work with her. She had assistant counsel, but she didn't have like a true secondary. But she also did have a private investigator.
With the competency issue of not requesting her to be evaluated. And so that was one issue. Another issue that we raised is Ms. Vander Ark testified at the time of trial. She's always remained consistent about her innocence. And
I don't claim to be really good at math, but excuse me, innocence. How, pray tell, Miss Vander Dork, are you innocent? Because the way I see it, when you actively take away someone's access to food, you feed them hot sauce, you put them in ice cold baths, you make them run up and down stairs, you fail to notice that they're becoming malnourished. I really stop caring about whether your, feelings are hurt or not. Also, how are you innocent? I'm still confused. You videotaped, you put, sensory loud alarms on your son if he moved. So how do you, are you using Lori math? Do I have to watch The Matrix, Bob Almighty, Bob's Burgers, and Ironheart to figure out where in the continuity and multiverse you are innocent, Miss Shanda Vander Ark? Because I am confused. Apparently. And she passed the LSTAT, so she should understand that unintentional is not a magic get out of jail card.
trial counsel, during his closing argument, made a statement to the jury that she was guilty of manslaughter. Well, my client never consented to that type of argument, never consented to a lesser included offense. So that's a second issue that we have raised, and is ineffective assistance of counsel. I've made a number of other areas that we felt that trial counsel was ineffective, and one was on the death certificate. The first thing that is noted is dehydration. And
because you didn't allow him to drink water, are you saying that... Sir, I am trying to protect the non-curseability of this stream at this effing moment. But are you trying to say that he died because he didn't drink the bath water in the ice bath that he was left in for 8 hours? What in... This man probably stood in front of a mirror and said, "This is a good idea. This is a great idea."
in this case, there was many allegations about Ms. Vander Ark restricting food to her son. But there was never any type of allegation about restrictions of water or liquids or fluid.
Oh no. Oh hell no. This a-hole is like, look, he didn't die of malnutrition. He died of dehydration, and she never said that he couldn't have water. I mean, I am rarely ever speechless, but they got me.
It's a bold strategy, Cotton. Let's see if it pays off for him.
I feel like I'm having an out-of-body spiritual overload of stupid that has forced my soul into the netherverse. 'Cause the hell kind of argument is this? Look, Your Honor, she might have starved him, but she didn't dehydrate him. Now, call me crazy, but I'm not gonna split hairs about a malnourished and dehydrated little boy. But you seem to think it's an effective defense, and you're an actual damn lawyer. Yikes.
And if you do any type of research in this area, you know, a person knows that they will die within days if they don't have any type of water. But a person can literally last weeks, sometimes months without food. And so with
Again, I don't know that these are points you want to be, throwing out there. Holy the dongle, is this a bad idea? These arguments are terrible. Look, Your Honor, as everyone knows, you can starve someone for a little bit, but if you don't give them water, they're gone. And it's not true. And I know you went to Dr. Google and Bill Nye, the science mechanical engineer, but no, you are not Neil deGrasse Tyson. Stop. Also, Neil deGrasse Tyson, stop being so insufferable. I used to like you.
dehydration as being the first statement in the death certificate, I think it was important to highlight that as a trial counsel, because that is what's the first statement. And I think in my reading of the transcript, there was only one question about that by trial counsel. I think the main focus in the case could have been or should have been that the real cause of death was dehydration, because there was never any type of restriction on water. But like I said, Your Honor, I have outlined.
Except that isn't true. That isn't true because he was told that he couldn't go upstairs, he couldn't leave his room, he was in stress positions, and if he moved, he got longer time in those stress positions. So while she might not have physically restrained him away from water, she still limited his access to it. She still forced him to stay in his room, still forced him to be monitored. This is a terrible argument. And Shanda, were you working on getting people to hate you more? Because I think you done made it an Olympic sport now with these arguments.
Did a detailed brief in this. I'd be willing to answer any questions that you might have.
All right, real briefly, I just want to make sure that the court understands the argument regarding the competency. The claim is, my understanding based on the brief, is that the competency or the incompetency, alleged incompetency, occurred not during the whole or parts of the whole trial, but simply at that moment when she was done with questioning at the end of the day. I think it was on the 14th. I think it was Thursday. Is that correct?
That is correct. So
there's no allegation that she was incompetent at any other point during the trial except for the moment she was done questioning. The court, I think, was going to break for the day or something like that, correct?
That's the pivotal portion of the case.
Okay.
Because she goes through, and granted, prosecutor did his job. I mean, he was tough on her, and that's his job, and I can appreciate it. But it had, a significant impact. Apparently,
No, sweetheart. It wasn't. Now, the prosecutor, I do love this prosecutor because he has no chill for Sandra either. And I love that. Or Shanda. Also, Shanda. Anywho. But this prosecutor did one of the better jobs at cross-examining her, which is why I wanted to go over her testimony, at least for this trial. But he did a wonderful job. And for someone who was just about ready to have a, mental breakdown or schism, she did a pretty good job trying to defend herself from the prosecutor's questions. Again, for a person who thinks she's very smart and very cunning, this is not the angle of attack that shows any sort of perception or ability to read the room.
my understanding is that she was pretty much paralyzed, and couldn't move.
Don't threaten us with a good time, because I don't know about you, but her paralyzed and unable to move on top of an ant mound, a fire ant mound, kind of sounds really nice right now. So don't tease me with something that ain't happened yet, allegedly in Minecraft.
and couldn't function the following day.
Okay, all right. That's all the questions I have at this
Thank
point.
you.
So, yep, thank you. Ms. Bloomquist.
Well, it's the people's position, Your Honor, that the defendant's not entitled to a new trial because she was not denied a fair trial on the bases raised in her motion for new trial. Specifically, her issue 1, dealing with competency. The test for this is there's a presumption by statute that a defendant is competent to stand trial, and that is MCL 333.2020 subsection 1. And the test that this court is supposed to apply, or the test that would be applied on an appellate basis of this court's decision not to hold a hearing, is that when facts and circumstances are brought to the court's attention, or that the court itself observes, raises a bona fide doubt as to the defendant's competency. That's when a hearing on the defendant's competency should be held. It's our position that in light of the facts before this court, the facts in the record, and the facts known to all parties involved, that there was not a bona fide doubt as to the defendant's competency. And our appellate courts have set forth certain considerations for a trial court, when it was situated as you were, to make this decision. The court can look to the defendant's irrational behavior, the defendant's demeanor, and prior medical records related to competency. And I guess the main crux of this, Metz People versus Camarad 307 Mich app. Your Honor, there was never anything in any of those 3 components that are factors for this court's consideration that would support that the defendant was in fact incompetent to undercut that presumption of competency. In fact, I would assert that the record before the court is that this was a feigned bout of incompetence to harbor an appellate parachute to undermine a jury verdict. And I think the court also is well aware that Ms. Vander Ark is a trained individual who might not be an attorney, but she went to law school, and by her own account, she was very smart, passed the bar, has all sorts of knowledge on certain things that she could do to undermine a jury verdict in this case. And People v. Camarad specifically says that if the defendant's actions are purposeful and are more or less a strategic game, it is not an expression of mental illness or a denial of reality, and it would be proper for the court to not find a bona fide doubt as to her.
Dang. Shanda, malingering doesn't count. Again, I would switch from the dehydration thing to maybe not intentional. Ask Sarah Boone. I'm sure she can send you a thing of, oh gosh, what was it? Blackburn's legal dictionary or whatever she used. I'm sure she'll send you one. She'll teach you how to make a poster for your appellate attorney. You guys will be great friends.
Competency. So turning to the facts in the record, Your Honor sat here and watched Ms. Vander Ark during the days preceding this alleged incompetency. She was present at counsel table mere feet from Your Honor. She testified before Your Honor. You were able to see her interactions with her counsel, with individuals that were part of her defense team, as well as to hear her testify. Nothing in what happened in the days leading up to this incompetency would support that there was a bona fide doubt as to her ability to be a part of her defense team. Further, I think with that, what's very relevant and highly probative to this question is there was a pleading almost identical to this that was filed on a motion to quash bindover to send this case back to district court, where Ms. Vander Ark alleged that during her preliminary examination, she disassociated and she was unable to be present because of this condition at her preliminary examination. She raised these same issues as to competency.
No, Tammy, I didn't. Now, the alternate juror, AJ, did, and I will be doing, at least Shanda's testimony, but, I did not cover this one. This was a hard one. I did, do background information on it, but this was a hard one. And Jason J., wow, my daughter thinks I'm a big dumb dummy. I told her that the carpet cleaning would leave the carpet damp, and she said, no, it didn't. Then she stepped on said carpet and said it's wet. Yeah, You have to learn the hard way, or at least I do.
The motion to quash was presented to this court, and my understanding from that is that the court was able to review her competency evaluation that was done by the Center for Forensic Psychiatry here in the state of Michigan. And as that report indicates, if the court would bear with me a moment. As that report indicates, the defendant had a, quote, sophisticated understanding of the roles of the various court participants, her defense options and possible outcomes, and clearly voiced her willingness to engage and rationally assist her attorney in this matter. And then the clinician went on to say, I did not observe any behavior indicative of an intellectual disability or other cognitive, physical, or psychiatric issues that would impede her adjudicative competencies. Your Honor, the court can absolutely consider all of that in making this determination as it relates to the defendant's competency, and I think that the record supports the...
Spoiler alert, he did, because this is Shanda trying to play the system, especially when this is a duplicate or a near duplicate of another, motion where she said she had mental health issues that would have precluded her helping with her, pretrial hearings and such.
That this court made the proper determination that she had not overcome the presumption
Look at those
that she's
angry
competent,
lips.
and in fact, not holding a hearing was the right decision on this matter. Now, to succeed on a motion for new trial, the defendant would have to show that there's a basis for appellate relief. And looking at your decision and this court's decision, there is not a basis for appellate relief on this issue. Now, I do know, I am prepared today to take additional testimony should the court require it on this specific issue in the form of individuals who saw her during this claimed incompetency who would be here to testify as to their observations of her outside of what the court itself observed in making this decision. And so I'd be prepared to do that today as it relates to issue 1. But
I love that she's like, I have what we like to call receipts and witnesses. And Shanda was just fine. She didn't feel like going to court that day.
ultimately, Your Honor, there is no basis for a new trial as it relates to her feigned or malingering incompetency that's been presented today. Turning to issue 2, as the court's well aware, the burden's on the defendant to prove that she was denied the effective assistance of counsel. And that burden's twofold. First, she has to show that there was deficient performance, and she has to show prejudice. And I'm going to be a little bit out of order here, Your Honor, because she has to prove both. She has to prove both prongs. And in light of the overwhelming evidence that was presented about this defendant's culpability and her guilt and what happened with her son, it's my position that she can never establish that any of these claimed instances of deficient performance, which I don't agree are deficient performance, but for the sake of argument, if you were to assume they were, she could never overcome that second necessary requirement of showing that any of Mr. Johnson's actions prejudiced her in light of the overwhelming evidence supporting her guilt. And I do have all of my responses to the prong 1 as it relates to those, as it relates to the individual claims of deficient performance. But Your Honor, I don't believe that the defendant can ever meet that Strickland standard and show that she was denied the effective assistance of counsel. I would note, however, like I said, for issue 1, I do have Mr. Johnson here, who, as well as another individual from his office, who would be willing and able to testify if the court were to order again their hearing. And I'd be happy to answer any questions the court might have.
All right, no, I don't have any questions at this time.
Thank you.
Mr. Ambrose, I'll give you a chance to briefly respond if you wish to.
I'm pretty sad.
Sir, don't try. Don't try.
Okay, all right. All right, well, as indicated by both attorneys, the court always starts with a presumption that's under MCL 330.2020 that a defendant of criminal charge is presumed to be competent to stand trial. That statute indicates he shall be determined incompetent to stand trial only if he is incapable because of his mental condition of understanding the nature and object of the proceedings against him, of assisting in his defense in a rational manner. There's case law that also indicates that, quote, a criminal defendant's mental condition at the time of trial must be such as to assure that he understands the charges against him or her and can knowingly assist in his defense. The court, obviously the parties know under court rule, either the parties or the court sua sponte has the ability to address the defendant's competency at any point in time in the trial proceedings. The trial court, specifically me, has the duty to raise the issue of competency where facts are brought to the court's attention which raise a bona fide doubt, that's in quotes, as the defendant's competence. That's specifically a quote from People v. Harris, 185 Mich. App 100. That is actually cited in the Camerad case. Mr. Ambrose cites the two primary cases. It's People v. Camerad, 307 Mich. App 98, and the federal case of Drope v. Missouri, 420 U.S. 162, a Supreme Court case.
There's a fundamental timing issue, Jedi Jess pointed out. But as the only witness for the defense and her having this catatonic or, feigned episode, after basically the defense had rested, even if she was incompetent at the end of that, the case is rested. And this was, again, I think everyone has called it fairly rightly from the state, a ploy to try to use her knowledge of the judicial system to try to get out of what the jury recommended, what everyone who saw the trial basically felt, which is, let's bury this woman under the prison, allegedly.
So essentially the question for the court is, did the court have facts in its attention that raised a bona fide doubt as to the defendant's competence? Essentially, the court is focusing on the morning, the 15th, I think it was December 15th of 2023. So the analysis, and also People v. Cameron says the test for such a bona fide doubt is whether a reasonable judge situated as the trial court judge should have experienced doubt with respect to competency to stand trial. Evidence of a defendant's irrational behavior, a defendant's demeanor, and a defendant's prior medical record relative to competence are all relevant in determining whether further inquiry in regard to competency is required. That is a cite from People v. Camerad, which also cites the Drope case. So the court begins its analysis in terms of what I, as a trial court, knew or understood, or at least had experienced regard to Ms. Vander Ark's competency or alleged incompetency, what her behavior was. This court, even prior to trial beginning, had reviewed Ms. Vander Ark's competency evaluation, which is referenced by Ms. Bloomquist, and the court also had an opportunity to review the preliminary hearing transcript. In normal circumstances, the trial court, my practice is not to review those things in case it's a bench trial, and then the court needs to remain impartial. However, at the stage prior to trial, as Ms. Bloomquist indicated, Mr. Johnson had filed a motion to quash the bind-over, or at least remand for preliminary examination, because of incompetency that had occurred or allegedly had occurred during the preliminary examination. The court's review of the preliminary hearing transcript indicated that at some point during the preliminary examination, Ms. Vander Ark.
Okay, I know it's petty and it's small, but it makes my heart just flutter with joy that she is having to try to figure out how to make a notebook out of a bunch of loose leaf paper. Because I know if she's too type A to function, this is probably bothering the snot out of her, that she doesn't have like a yellow legal pad and she's having to flip things over. And so it makes my heart feel happy that she's just mildly put out, because I know it irritates her.
Had allegedly experienced some distress. I think it was described as maybe a panic attack, and that Mr. Johnson had asked for a brief recess to allow Ms. Vander Ark to compose herself. Judge Maria Lattice Hoops in the 6th-year district court was in a unique position at that point to observe the defendant and her behavior, and indicated that she, I think it was almost a quote, that she looks fine, and she proceeded forward. So another court sitting, presiding over a hearing at the time that one of these alleged panic attacks occurred, observed the defendant's behavior, made a determination that she was competent to continue forward. I think it's also important to note the panic attack that occurred in district court occurred not randomly, but after her co-defendant, Paul Ferguson, took the stand, which seems to be rather convenient. But again, the court also looks to the judgment of the district court, who had a chance to observe this panic attack and made a determination that they would move forward. The competency report gives no indication that Ms. Vander Ark was incompetent. Just for purposes of the record, the competency report was dated November 16th of 2022. The preliminary hearing actually occurred on January 4th of 2023, and that.
And if you are new to watching trials, I'm not a lawyer, but I have learned some things. So if you're new or lurking, anything prior to the trial being done or the case being rested, the courts and by statute, the judge is supposed to weigh things in favor of the defendant. So if given a piece of information, he has to decide whether it's probative and actually has something involved with the case, or it's prejudicial, or, if I rule, he is supposed to rule with deference to the defense. Now, in a presumption of innocence. When she is in this appellate, sphere after she's been convicted, the court starts off with the presumption that the state or the court was correct in their proceedings. So she does have the burden of proof now. The defense never has the burden of proof when they're actually at the trial, but any appellate issue, the burden of proof to prove that there was prejudice or anything, that detrimented the trial, that burden of proof to show that there were negative effects is now on Shanda. You'd think she'd have figured all this out before she decided to start a life of crime and be a slime ball. But some of the smartest people are some of the dumbest people you'll meet because they just don't have any street smarts.
The competency evaluation indicates in several instances that she was competent. Specifically, this is page 3, a quote from the competency report that says, during the interview, Ms. Vander Ark was alert and oriented to place, person, and context. She demonstrated an ability to retain and mentally manipulate verbal information, to remember multiple items after several minutes, and displayed a sound reality testing and good judgment with regard to hypothetical situations. Ms. Vander Ark's memory was good with respect to ability to recall relevant details of her background, history, and activities around the time surrounding the alleged instant offense. Her cognitive abilities are estimated to be at least within average range, as evidenced by her education and performance with respect to above-listed capacities. This estimate is supported.
Ooh, that chafed her ass. Being considered And Jedi Jess says that's not quite accurate. Competency is presumed and the defense has to rebut that. Additionally, for a motion to dismiss, evidence is taken in light most favorable to the state, not the defense. Thank you. Jedi Jess is right. I am not a lawyer. That being said, I still am a conductress and a head of a, slightly growing semi-joke church, which I hope my mother does put on the little Christmas card when she writes out what we've been doing all year. Mo has a semi-professional hobby, and I think she's starting a cult.
By her self-reported academic and employment history, as well as her conversation style, vocabulary, and ability to reason throughout this interview, end quote. Later on, there's a list in this report of her understanding of the nature and object of proceedings against her. I don't want to read the whole thing, but clearly She understands exactly what's going on, the understanding of the roles of courtroom personnel, her involvement, in her defense, her counsel's responsibilities, the prosecutor's responsibilities. Ultimately, under the section labeled competency to stand trial opinion, the examiner indicates in quotes, I did not observe any behavior indicative of intellectual disability or other cognitive, psychological, psychiatric issues that would impede her adjudicative competence. It says, in my opinion, Ms. Vander Ark was aware of the charges against her, how they came about, and provided a consistent version of how events unfolded from her perspective. She considered her defense options as reasonable expectations and appeared legally knowledgeable. In my opinion, Ms. Vander Ark demonstrated sophisticated understanding of roles of various court participants, her defense options and possible outcomes, and clearly voiced her willingness to engage and rationally assist in her attorney in this matter. In my opinion, Ms. Vander Ark was able to understand the nature and object of proceedings against her and to rationally assist in her defense. Therefore, in my opinion, she is competent to stand trial. Just because, obviously, I'm sure defense would argue that just because she's competent at one moment doesn't mean she doesn't become competent in another moment, but that's certainly something the court had reviewed prior to my interaction with Ms. Vander Ark up in circuit court. Then the court had a chance to observe Ms. Vander Ark at trial. Ms. Vander Ark appeared to be calm, collected. She interacted with her trial counsel, Mr. Johnson. She appeared to be writing notes, handing those notes. She interacted with Mr. Goings, her co-counsel, along with Mr. Johnson, and she at least appeared to be very involved in her defense.
Yeah, so Shanda is not the type that she was going to let another person do her defense without her input. And she's got two competing, desires at this point. She doesn't want to look, or she's wanting to look incompetent, but she also doesn't want to look stupid. So she has two competing desires. And the fact that she's very, very proud, and one of her key kind of components of her identity or how she sees herself is, being very well educated and very smart. So you would think she would have planned this out better, is all I've got to say, because she was over there writing notes and talking and, helping shape her defense. And now to come out, I was too broken up to do it.
Defense, the court has presided over several trials, and Ms. Vander Ark appeared to be more involved than many defendants are. Typically, defendants say a few things and they kind of leave it up to their attorney. Ms. Vander Ark was practically appeared to be a co-counsel sitting at a table. The first indication of any distress on Ms. Vander Ark's part
made sense.
didn't occur at any part of the trial, even when her co-defendant, Mr. Ferguson, was testifying. During all the other witnesses that potentially testified, the first incident that could be considered potentially an issue or concern for the court occurred during the last day of trial on the 14th. Mr. Roberts was cross-examining her, and just to be clear for the record, the court has not only reviewed the trial transcript, the court actually rewatched the entire trial.
Oh, yes. As a warning and spoiler alert, when we do get into the, testimony of Shanda, we probably won't get into her cross-examination today, but the state attorney gives her no chill and decides to show her a picture of Timothy at the autopsy, really, really showing in great detail how emaciated, malnourished, and just pitiful this child looked at the time of his death. She pretended to fake upchuck. Now, as a woman who has dealt with morning sickness for 6 times, I can tell you that she might have gagged, but she did not throw up, because usually, you get that gagging sound and then a liquidy sound. There was no liquidy sound. Not that, I'm just saying, as a mom of 6 and one who's been dealt with morning sickness 6 times, that was not real. But she did pretend to upchuck because she was overcome with emotions.
Because you do not get the same feeling for Miss Vander Ark. You can't get it from the transcript because there's no indication of how she's acting when other witnesses are testifying. We have the fortunate ability to have cameras basically focused on the defense table, prosecution table, so the court was able to observe Miss Vander Ark's demeanor throughout the trial. But specifically going back to December 14th, Mr. Roberts showed a picture of the deceased Timothy to Miss Vander Ark, and she had this episode of vomit.
We're probably not going to get to it today.
That occurred at approximately 3:51 and 36 seconds on December 14th. Everything calmed down, even apparently after that, and we resumed testimony only 10 minutes later. So being confronted with, even if for argument, Miss Vander Ark is completely innocent of these charges, to see her son in that manner certainly, brings out a vomiting issue, but she's just ready to go after 10 minutes. Completely fine.
Roll your eyes under your lids one more again. Like I said, this is my first rodeo. I have seen eyes rolled at me.
And then Mr. Roberts continues to cross-examine her until 4:48 and 11 seconds. Mr. Johnson then does redirect until 4:51, and Mr. Roberts again recrosses her until 4:52. And during that whole period of time, again, she appears to be calm, cool, collected. She doesn't appear to be crying, and appears fine, doesn't appear to be suffering for any mental distress. And then 8 minutes later, as the court is discussing jury questions with the attorneys in a sidebar, there's a mental distress 8 minutes after any questioning is concluded. So that was what the court had a chance to observe that date. The court didn't receive any information.
Shanda, you are so dumb. Now, are you going to tell me you had an acute, delayed, dramatic reaction? Because no.
From the jail staff or counsel or anybody that she was suffering any distress. After that, the court broke for the day and then resumed in the morning on the 15th. At that point in time, the court was going to start at 9 a.m. And Mr. Johnson indicated to the court, I think it was in chambers with Mr. Roberts present, that they were having some issues with Ms. Vander Ark's ability to come to court. It's unfortunate that these things were not placed on the record, but not specifically remembering everything, but the impression was for the court was that Ms. Vander Ark was suffering some mental distress, was upset.
Shanda, you're so lucky I'm not your judge, because you would have come in on a dolly looking like Hannibal Lecter. She is writing notes. Christy Garcia, she did train to become a lawyer. I don't know where she got, and as far as the process, it's been about I want to say a year or two since I've looked at the trial. But she is very, very aware of legal sort of maneuvering. She did pass, I think she has gotten her legal degree, but I don't know. I know she was working as a clerk for a judge, but I don't think she had taken the like licensing exams and stuff yet to actually be a lawyer. Yeah, she knew she was effed. And she has to know that the dehydration over starvation is a very stupid argument. And she thought she could get away with it. She thought she had the perfect patsy in Paul, and she could blame everything on Paul, and people would feel sorry for her, with all of the struggles she had, according to herself. She banked on everyone seeing Paul, seeing how incredibly awkward and, fidgety he was and blaming him on everything. At least that's my speculation. My speculation was she was going to throw Paul under the bus. And fortunately for Paul, although he is where he needs to be in prison, everyone was able to see who was the mastermind, who was the pinky, and who was the brain. Jedi Jess said they say she passed the bar, so if she paid the fee, she might have her license. That being said, there are many types of clerks. She could have been the clerk's research or the judge research clerk. Yeah, I know she had. She was trying to clerk and get into appellate law of all things, which does kind of raise my "this is BS" antenna. That this was the exact sort of work that she wanted to get into, and she was going to focus her, futuristic legal career in. So, also, Shanda, just for a thought, you might not want to try a legal Hail Mary when you have been convicted of being a demonic swamp monster. You kind of don't get, Hail Marys when you're a demon.
Was crying, but it was never brought to the court's attention that she could be incompetent. Now, I did have a chance to review the transcript. Mr. Johnson refers to the competency of his client. And in the context of everything that's going on, the court finds that not to be an expression of competency to stand trial, but competency in terms of her mental health is such that she's in a upset state.
Good for you.
There was no other indication that potentially Ms. Vander Ark was incompetent to stand trial. The court waited 2 hours. It was then discussed with the court that she was going to waive her right to appear in person. And the court obtained a written waiver from Ms. Vander Ark, indicating that she did not wish to appear. The argument being made at the time now is that Ms. Vander Ark, at least according to her affidavit that was attached to the brief filed by her counsel, was that she does not recall signing that. And
Did you just become a police officer for, Canton PD? It was a false memory. I had a false rememberation of what happened. The pen in my hand is... No, this is not liar, liar. You did not go into a fugue state and suddenly start signing things like you are signing pardons at the end of your presidency. This is not how this happens, ma'am.
Throughout the trial, Ms. Vander Ark claimed lapses of memory, but it was clear to this court that those lapses of memory were self-serving, and that her ability not to remember things occurred during periods that she could be either criminally culpable or at least the things that she had said would hurt her defense. So her allegation now that she does not remember that is rather convenient, that the one component that she does not remember when she was in the jail was signing a waiver to appear. Her affidavit indicates that she was aware of other things that morning, but she's not aware of that.
I often forget signing waivers.
So based on all that, what the court had an opportunity to observe, I will indicate this. Mr. Ambrose indicated that these facts are like Drope. The Drope case involved a report from a psychiatrist that was given to the court regarding the client's mental health status, and which raised a doubt that in the
Shanda's furiously looking on her little tablet how to get on to BetterHelp. She's like, yes, I am very needing to talk to someone. She's like, could you write me an excuse note for, convictions? And Jedi Jess says also her ability to pass the bar shows that she doesn't have memory issues, at least before this and in stressful situations, because there's a lot of memorization when studying for the bar. Yeah, I figured it was fairly complicated. And would have to require a lot of careful attention to detail and stuff like spelling for lawyers that's necessary.
Psychiatrist had recommended that the defendant in that case undergo a mental health evaluation or competency evaluation. That we don't have that here. We don't have a psychiatrist that gave a report. Defense counsel didn't give a report to the court or say there's a concern, or we got a report from somebody indicating that, you know, she needs to be undergo a competency evaluation. We don't have that here. What we have is the court's observations. A lot of these panic attacks seem to occur in moments where
She was being held accountable. Yeah, she has accountability-itis. She's allergic to what we like to call responsibility. And thank you so much, this pickle chick 89 boo. Thank you, thank you.
there could be some critical or really prejudicial information that potentially is coming in at the time of trial or prelim. They don't seem to be random, they seem to be calculated. So the court, based on all those things the court had observed, the question for the court is whether the information for this court raise a bona fide doubt.
And Jedi Jess says it's 2 days of testing your knowledge and ability to play the law, and it stretches all areas of law from criminal to civil to corporate law. Oh, that sounds like a whole bucket full of nope. That being said, I also say that when looking at Sudoku puzzles, so maybe if they made it multiple choice and didn't have math.
As to her competency, or that she should be undergo a competency evaluation. And the court says that my ruling is that a reasonable judge sitting as what I was looking at would not have a bona fide doubt. That it was, at least according to this court, was clear that she was competent. Now, was she suffering some distress? Yes. In most trials, cross-examination is very stressful. Mr. Robinson is a seasoned trial attorney. He engaged in very good cross-examination, very pointed. That is upsetting to most witnesses. And I have no doubt in my mind that Ms. Vander Ark was upset and potentially didn't want to come to court to face more of the cross-examination. But there's nothing that was before this court at that time that raised a bona fide doubt as to her competency to this court. Now, as to the issue of actual competency, whether or not she was competent, again, there's two standards. One, should the court have held a competency hearing? That's based on whether or not the court had a bona fide doubt as to her competency. So the court finds that it did not have a bona fide doubt as to her competency. The fact that the question is, was she competent? Again, there's the hearing, and then there's whether or not she was competent. Now, Mr. Ambrose, in chambers, we talked about potentially taking testimony as to Mr. Johnson's observations of Ms. Vander Ark, as well as any other caseworkers that met with her. This court finds that I have enough information in front of me to make a ruling today. However, I will reserve the opportunity for Mr. Ambrose to call witnesses, or the prosecution to call those witnesses. But I am going to make a ruling on that issue today without prejudice so the court can hear additional testimony. Mr. Ambrose has requested that if that testimony occurs, that he would like his client here. I don't have an objection to that. Having previous history as a defense attorney, the advantages of having your client right next to you during cross-examination or during examination are incredibly important. So he said, if we're going to have testimony today, and I think his client has expressed that she would like to be here, I don't have any objection to that occurring. And so likely that will leave us in a position where we'll have to have a hearing at a later date where Ms. Vander Ark will be present. However, in terms of the court's finding of competency, Ms. Vander Ark attached an affidavit to the brief filed by her attorney. And I think a portion of that is very telling in terms of her competency. Specifically, I think it's page 11, last paragraph. She indicates, I testified for around 5 hours on the Thursday of trial, was supposed to finish my testimony on Friday. including some very important questions that I wanted Mr. Johnson to ask me before I finished testifying. However, I had a severe...
Okay, so I was wrong. Now, I said that they had closed their case or arrested their case. Apparently, they hadn't. So the trial wasn't over, but it is extremely late in the game for her to suddenly have competency issues. And this was probably when she was trying to do her sob story and looked over at the jury and realized she was getting nothing. I think she was getting the dead stares, note taking, but she realized in her own way that she had no one on her side, that her testifying, her trying to put a sympathetic spin on her reasons or excuses for her behavior did not fly. That's why she didn't show up. She didn't have a disassociative thing. She just realized no one was buying her bullcrap. And you can't be a narcissist. You can't lie to yourself over and over again and paint yourself like Lori and have people who aren't buying it.
Severe mental breakdown on Friday morning. I had several panic attacks and was completely paralyzed, unable to even make it to the elevator to go to court. I curled up into a ball and was barely able to communicate. During this time, I specifically asked Mr. Johnson to postpone the trial until I was able to participate. When I asked this, he said there was no point in delaying anything. He stated that they could continue without me. I never agreed to waive being in court for the rest of the trial. If there is a document with my signature on it, I do not recall signing it. Further, I was in no condition to agree to proceed without my presence. The standard...
And Jedi Jess, did they ever treat the kid properly? Like, was it something new? So, from my knowledge of this case, and I didn't dig into, and they are private, or I'm not sure how one accesses the family court, but Shanda and Timothy and her five of her six children, their father, as far as I know, Shanda was actually removed, or they were going to remove the children if Shanda didn't relinquish her parental rights for not only Paul, but I think all five of those siblings. Now, she did have another child. He's called G or Little Man in the trial. He is a minor. I think he was 7 or 8 when the death occurred. As far as I'm able to dig in, the only child that Sandra or Shanda, I want to say Sandra, but Shanda just doesn't seem like a real name to me. I apologize to any other Shandas that are out there or Shandas. That being said, as far as I can tell, watching everything and getting all the information I can, her final child, the sixth child, is the only one she did not mistreat. Because she was basically had her parental rights taken away. And family courts being what they are, she had to be very, very bad for them to terminate her rights, especially being a woman. So I don't know what hell these children lived through before she got them back in her clutches. But it will come out in the trial and in the testimony when Shanda is asked. She technically was not supposed to have any contact with these children. So there were a whole lot of resources that she didn't tap into in her locality because it would have, shown up as she's trying to, get her bona fides as an appellate lawyer. I do believe that this happened in Oklahoma. So the children being taken away from her happened in Oklahoma. Now, that being said, I do know that Timothy's father, or at least the way that Shanda tells it, and his father has never come forward to speak publicly or privately that I've been able to find about this case. Because of Timothy having some special needs, autism, sensory issues, and just different needs, he was overwhelmed. He couldn't take care of him. And he was going to either give Timothy to Shanda or put him into foster care. And I do think that Nanny Goat, she treated Timothy fine when her second husband was in the house. There were valid allegations of child grossness going on, which is why she lost her rights. So why this man would think that leaving his son with her would be the better alternative, I know foster homes suck. I know our child, safety net needs to be fixed. But I get a little irritated on this thing, and we'll get into why I get irritated when we get into Shanda's testimony, because I had to take him or he would have gone to foster care, and I can't let my baby go to foster care. They get hurt in foster care. Said by a woman who systematically denied food to her son for a long period of time. But she had to protect him from foster care.
For competency to stand trial is different than potentially just being unable to move or being unable to talk. What competency is essentially is, do you understand the object of the nature of the proceedings against you, and do you have the ability to assist in your defense in a rational manner? Ms. Vander Ark is indicating in this affidavit, indicating that she knew there was trial going on that day. She also
Yeah, her ability to instruct her lawyers would mean that she was competent and directing her lawyers, which would prove her competency. Like, Shanda, did you think any of this through?
indicates she had very important questions that she wanted Mr. Johnson to ask. She understands that Mr. Johnson's his attorney, that he asks questions. She's apparently of enough sound
Exactly
mind
true,
to form
Jess.
important questions for him to ask. She also understands that, that she asked to delay the trial. So she's aware there's a trial going on. So, looking at those things, when you go to the competency element, again, it shows the court that she has an understanding of her attorney, the prosecutor, the trial, those things that are going on, but she wanted to proceed with her presence. The court is not held slave to somebody's being upset that they don't want to go to court. The test is competency to stand trial. Are you competent to stand trial? Not that, well, I'm crying and I'm just really panicked and I'm in, that's not the standard for the
Oh,
court.
she is raging out.
Now, the courts give a lot of discretion
Seethe.
to allow a defendant time to calm down or witnesses to calm down to see if they can proceed. This court allowed Ms. Vander Ark 2 hours in the morning. And it was then, and quite frankly, there was no threat to Mr. Johnson, or not much of a threat, but there was no indication that, well, Mr. Johnson, we got to get rolling right now. We got to go. It was Mr. Johnson, her counsel, that said she wants to waive her appearance here and wants to go forward with me representing. And based on the court's finding that she was competent at that time, her appearance, her lack of appearance was voluntary. She voluntarily did not want to appear, and that's evidenced by her written waiver. And again, she's saying, I don't remember that. Court finds that to be self-serving. She doesn't remember something that could hurt her defense legally.
Yeah, I don't think she does the same exact thing Lori does. That's the thing that I don't get. So Lori has her ignorance, and I mean, she is malicious, but she's just ignorant of the law and procedures. So her, supposed unfairness, the unconstitutionality of her trial is just because she doesn't understand anything and nothing was done wrong, in her case. And thank you, Unbalanced Equation, for the Mr. Mo Education Fund to inform him you are great. Well, he's great too. I forgot, and I do mean absolutely, abjectly, shamefacedly, embarrassingly forgot an important telephone meeting I was supposed to do yesterday, and did not remember until he asked me how it went. Thank you so much, Unbalanced. And I apologize profusely, but he was not a butthole to me. And to be fair, I might have had a bit of an attitude had the situation been reversed. So I'm going to try to remember that the next time he forgets stuff. But I did make a pretty big boo-boo. In my defense, not excusing my inability to remember anything, uh, the house like 2 houses down got struck by lightning. They're fine. There wasn't any real big damage, but it was loud as hell. Everything, all the hair on our arms stood up. I was with the young feral boys, and I totally forgot about the phone call. So he is pretty great himself, too.
There's specifically People versus Swan 394, Mich 451 indicates, quote, a defendant's voluntary absence from the courtroom after trial has begun waives his right to be present and does not preclude the trial judge from proceeding with the trial to conclusion. There is, at least in the court's estimation, there was a valid waiver signed by a competent, legally competent person. That was the court's, that's the defendant's voluntary absence. She chose not to be here. The court proceeded without her. Even in absence of a waiver, the test for determining whether a defendant's absence from a part of trial requires reversal of his or her conviction is whether there is any reasonable possibility of prejudice. So the other question is, even if Ms. Vander Ark had not waived her right to be there, and even if she potentially, I don't want to say incompetent, but the fact that she was not there, the court looks at the prejudice component. The trial was concluded. The only thing left was jury questions and closing argument, deliberations. That was it. And so based on that, the court finds the possibility of prejudice was minimal. The court explained the absence of the defendant to the jury, said that she was suffering from medical distress. She wasn't an order for her not to appear. She didn't do anything wrong, essentially, but she was not going to be here. And so the court finds that there was no prejudice to her not being here. Now, the other interesting thing that the court last night reviewed the video again, there was this question of, there was questions that want to be posed to her. The traditional examination stage is essentially direct examination, cross-examination, redirect, recross. That all had occurred, and it went back to redirect after Mr. Roberts had recrossed, and Mr. Johnson essentially said, we're done with our questions. The only thing that was left was jury questions. Jury questions are in the discretion of the trial court. There is no right by a defendant to have a jury question or offer her questions. So essentially, the component that was, even if she is not here, the component that she gave up was presence for jury questions, which may or may not.
And if you're new to watching trials, there are certain localities that do allow juries to ask questions. So what will happen is you'll go through the normal direct, cross, redirect, recross. And then, so I believe Arizona, Indiana, and I want to say, was she Michigan or Wisconsin? Okay, and Michigan, but I do think Wisconsin might as well. There are several places that in Florida. So there are several places where then the jurors will write down their questions. The judge and both parties will look at them, see if they are legally, cogent questions, make sure that, everyone is okay with them being asked. And then, the judge will generally read out the jury's questions and allow both sides to ask more questions, kind of just based on the answers that they got from those questions. I like when localities or areas do allow jury questions. You find, like in the Karen Reed case, there was one or two very, very intricate questions about some of the, I am going to mispronounce this, gas chromatography or sort of the scientific readouts and trying to figure out whether the plastic was from a tail light or even related to each other. So you do kind of get a sort of understanding of what the jury isn't understanding. And I think it would help lawyers tailor their questions, because sometimes I think lawyers, go into trials with the mindset of, kind of talking to other lawyers, and they forget that they're talking to a jury to whom all of this is a bit foreign and a bit odd. And, a different way of reading, in normal nonfiction or even fiction reading, if you transpose and for or, it it will change the context, but it's not going to change the entire flavor of a sentence, of a meaning, of things like that. So I wish that more localities would let jurors ask questions, because I think there are, perspectives that they just don't think about, and it kind of gives the access to more information, more questions, more evidence, or at least kind of gauging where you are in a trial.
Have been admissible, may or may not have even been able to been asked her, and it's something that was not a right of the defendant to have a jury ask her questions. All the things that typically come into a trial occurred, and the defense was done asking her questions. So there is no guarantee at all that she would have been asked any more questions whatsoever, and she didn't have a right to have those questions posed to her, although it was the practice of the court. So all those things, the court is finding that she was competent. It does not warrant a new trial in this case. There was no bona fide doubt that she was not competent to stand trial the morning of. So with the reservation that I've already made in terms of additional testimony from Mr. Johnson or another caseworker, which needs to be called at this point in time, the court is making the ruling that the motion for a new trial based on incompetency is denied. In regards to the basis for relief off of ineffective assistance of counsel, Mr. Ambrose does raise some, I think, are legitimate issues regarding defense strategy. Both parties know that many of these decisions not to call witnesses or not to question about certain things or not to raise certain defenses are a matter of trial strategy. However, the court feels that that record needs to be developed more with Mr. Johnson, Ms. Vander Ark's trial counsel. In particular, of concern to the court is the allegation that Ms. Vander Ark did not authorize Mr. Johnson to essentially concede guilt to voluntary manslaughter. That is a pretty significant issue, which many times leads to reversal and a new trial if that actually can be proved to be true. I don't know that, but I think I think it's irresponsible of the court to simply make a decision on that based on just briefs without further developing that issue. So in regard,
I foresee that being the main vector of attack now. And honestly, again, I'm not a legalologist. As a bystander, I think the more effective strategy for Shanda, not that I want to help her, isn't going to be the dehydration versus no food argument. That's a crap one. That's crap spackle, if you ask me. This allegation that she did not sign a waiver to go ahead and basically concede to manslaughter, or that she did not, in fact, sign the waiver stating that they could go forward without her, is going to be a much more fertile, in my opinion, way for her to go. That being said, I didn't like her lawyer's style, but I think he was far from the worst lawyer that we've seen.
regards to the motion for a new trial based on ineffective assistance of counsel, the court is going to grant the defense a Ginther hearing for those issues raised in the brief. That will not occur today. As I indicated, Mr. Ambrose would like his client here for questioning, and I think that is a reasonable request based on this motion. So the court will set that for a further evidentiary hearing at a later date. Mr. Ambrose, anything clarification from the court that you'd like, or any issues that you have for the court at this time?
Just one thing, and I put in my brief that I never did receive that waiver. And if I can just put the written waiver on the record of what was signed by my client.
Yeah, that's fine, that's fine.
It says, I, Shanda Vander Ark, defendant, agree to waive my right to be in the courtroom during the trial of Timothy Ferguson. I mean, and that's dated December 15th, 2023. So it seems somewhat, and I just received this today. Because in my review of the court file. Now, if that has any impact, if the court wants to evaluate that maybe my client didn't. She's obviously, her record, her past, her history. She's pretty much on top of things. Doesn't.
Well, like I said, I've made my ruling. It doesn't change my ruling, Mr. Ambrose, but I appreciate that, bringing that to the court's attention. So, I also want to make it clear for the record, the waiver was in the court file. Unfortunately, it was misscanned in circuit court. It was actually attached to the jury verdict. So when the court received the motion, I looked for it too, and I could not find it. And eventually, my staff realized that it was actually scanned inadvertently on the there's a second page of the jury verdict, which it should have been separated out. So I think it should have been provided to you as part of the court file, Mr. Ambrose, if you received the jury verdict. But I don't know. Like I said, it may or may not have been in the material, but if you ask for the record, it should have been in there because it was a digital copy, but I won't hold you to it. Anyway, Ms. Bloomquist?
Nothing further from the people, Your Honor.
All right, so the court will schedule this for a Ginther hearing at a later date. Thank you on both well-written briefs, good arguments, and we'll see you at a later date.
Judge, you don't have to lie. That dehydration versus malnutrition argument was, that's like trying to sell someone a Zeppelin after the Hindenburg. It's like, it's not flammable anymore. It's helium. No, the blimp thing has kind of moved on after it, went down in a fiery blaze of glory. But now we get to see Miss Land O'Lakes in her most redonkulous form. Yes, her testimony. Now, she does make really weird microfacial expressions, and I'm not sure why she decided to look like the Land O'Lakes butter girl. Between the baby hair or the baby ponytail and this chick, I have seen some hair disasters in court.
Raise your hand, please. In this matter now pending, you swear or affirm
And spoiler warning, she has the exact tonal quality of a mega cahoon. In the hearing, I think they were picking up background from the jail. I did look at another source, and it also had that noise in it. So hopefully this will be better, since it is, just a rewatch. Let's get into this. And I'm almost 2 hours in, so I can curse because I'm going to need it.
testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God.
I do, yes,
All right, put your hand down, grab a seat. Please state your name for the record, spelling your first name and then last.
Shanda, S-H-A-N-D-A, Vander Ark, V-A-N-D-E-R, space capital A-R-K.
No hyphen?
Thank you, Ms. Vander Ark. You're being called to testify in your own cases. You understand that?
Yes, sir.
And to do that, you have to make sure that everyone can understand you, correct?
Yes, sir.
With you, and knowing as I do, I don't think volume's going to be a problem with you.
Probably not, sir.
Talking fast, maybe.
Yes, sir, it might.
Okay, so this is, are you nervous?
Yes, sir.
This is stressful?
Yes, sir, very.
So you're going to be, questions going to be thrown at you fast and furious. You've seen how trials work, correct?
Yes, sir.
Okay. And under those circumstances, you may speed up again as I do.
Yes, sir.
Okay. You may be reminded from time to time to slow down just a little bit. Do you understand that?
Yes, sir.
Okay. All right. Let's make sure everyone understands you. You've been sitting through this trial for since the beginning, correct?
Yes, sir.
Back when?
July 7th of 2022.
Okay. So you've been living with this thing for more than, 18 months?
17 months. Yes.
17 months. So you know what we're talking about, correct?
Yes, sir.
And you understand the allegations against you?
Yes, sir.
And that it also helps that you have a...
Did someone dot her I in Gen Pop, or does she just have eye bags like me? Because I mean, I'm not saying that it would make my day if someone happened to deliver a little misdemeanor, a little venial sin of, you know, Gen Pop justice. Again, I don't know why she went with the field hockey look. She does look like she'd be an enforcer in roller derby, though. Gotta say, I'd be afraid of her.
Legal background, correct?
Yes, sir.
Okay. The things they said about how well you did in school and all those things, were those all true?
Yes, sir.
Okay, I'm not just sitting there and regaling this, but the things about cum laude, going to law school, all that stuff is true.
It was magna cum laude, yes, sir.
Okay, thank you. All right.
Oh, that pissed her off. She probably had notes. Like I did magna cum laude and I was an honor roller in high school. Oh my God, Sarah Boone and you have to meet. You can talk all about getting honor roll before you became, murderesses. Bestest friends forever.
Let's go back to the very beginning. When
She
you,
definitely does look East German.
okay. When did Timothy come to your care?
May of 2021.
Prior to that, who had physical and legal custody of Timothy?
My ex-husband.
Okay. And when he sent, and how did it happen that you ended up with custody then?
My ex reached out to me, stating that Timothy he could no longer handle him, that he was pushing his buttons, and that he needed to send him to live with me.
And John, thank you for the super chat. Vander Ark, I wonder if her safe word is something. I'm guessing she's not the one that says the safe word. I'm guessing she's the one that's the dom. I just don't see her as a sub. But maybe I'm wrong. Maybe she likes, a little domination. I'm sure she'll find that in Gen Pop. I mean, happy ending for not her. Although, seriously, if you had to wake up to that face, I don't think I'd switch teams.
And you agreed to that?
Yes, sir.
Okay. Had you ever lived with Timothy during his?
When he was younger, yes, sir.
Okay. All right. So you agreed to accept him into your home?
Yes, sir.
And who was living in your home at the time?
Myself, my husband, Adam, Paul Ferguson, and then my little man, G.
G.
Unbalanced equation, I agree. She does. Maybe, if she hadn't been felonious, she might have been in, a little rural English town, getting her kink on, I guess. I do feel sorry for that little rural town where people just go to get all freaky in a field for some reason. Like, there are hotels. There are shady hotels. You could do this in a hotel. Thank you so much. Yeah, the thing is, I don't trust her to listen to my safe word. Even if I had one, I just don't think she'd listen. Not to mention, that is a scary damn face, and no.
Okay, that's what we've been calling G, correct?
It's really hard to do, yes, sir.
Okay, just do the best you can. Okay, so they're all living in your home, and then Timothy joins you, correct?
Yes, sir.
When Timothy's joining you, did your ex-husband ever make any effort to transfer legal custody to you?
We discussed it, but he never did actually sign anything, no, sir.
Okay. And without legal custody, how do you get Timothy into school?
You can't.
And without legal custody, how do you get medical treatment for Timothy?
You can't.
Did your husband at least send his, I assume he had medical insurance for Timothy, did he send that?
He did not send me. I requested his medical card, his insurance card, and he never sent it to me.
Now, you heard the testimony that Timothy...
Now, what she is failing to mention again is that there are resources you could use. If Timothy had run out of his medication because he had ADHD, sensory issues, autism, and was on, unfortunately, when you have a lot of these sort of complex developmental issues, you do have, several to a lot of medications that you have to take in order to help you. So, from Timothy's point of view, he was dumped at his mother's house, who he hadn't really been around for years. And then he is not slowly weaned off all of his medication, helping deal with, his, you know, symptoms and sort of side effects. This woman is evil. And what she fails to get is what every single one of these, monstrous females don't get, is that a normal person wouldn't take. That's not 100% accurate if she's the biological mother, unless there was the court order saying different. She can do all those things without issue. Now, Jedi Jess, I did want to ask you if her parental rights have been terminated, but she still is the biological mother. He wasn't important. She didn't make an effort to see what avenues she needed to, go through to get him into school, to get his medication, to make sure he had the therapies that school generally offers, speech, occupational. Sometimes there's emotional therapy or counselors that come in for children that are struggling with developmental issues. Generally, schools have entire, behavioral plans. She isolated and kept this boy as her own personal toy. That's different. There would be a court order terminating her rights. Okay. And again, I know that so Timothy had no one else. The real tragedy is, and I do encourage you on a day where you can handle it, to listen to the victim impact statements of Timothy's oldest brother and his big sister. That young man would have taken Timothy if his father had reached out and said, "Hey, we're struggling." That young man would have dropped everything and taken Timothy. But instead, he dropped her off with a woman, a monster that he knew was unsafe. Now, like I said, having dug into this case slightly, as far as I've been able to dig into, there has never been a public nor a private or any sort of statement put out by Timothy's biological father about anything regarding this case.
Timothy saw a doctor in 2019. Did you hear that?
Yes, I did.
That was a year before you received him?
2 years before I received him.
2 years before. So in the prior 2 years before you received him, as far as you know, based on what you heard here, your ex-husband never took him to the doctor?
As far as I know, yes, sir.
How do you know if he had medical insurance for this young man?
He told me he did.
Okay. But he never sent it to you?
No, sir.
Okay. What was your financial situation once Timothy arrived and your husband had a stroke?
After the stroke, we
Yes.
lost my husband's income, and it was paycheck to pay, not even paycheck to paycheck. Almost everything was paid late. I was struggling. I asked Paul for help with groceries sometimes because we were struggling.
Okay. And Paul was working full-time?
He was working part-time.
He's working at Applebee's?
Yes, sir.
Okay. So he's working part-time, and so were you receiving any child support?
No,
So the entire financial burden was on you?
correct.
Could you have afforded daycare for any of your children?
Absolutely not, no.
And could you have afforded any extra expenses other than the ones that you were providing for?
No,
What type of expenses were you able to provide for this family?
just basic living expenses.
Rent,
Yes, sir.
utilities,
Yes, sir.
food?
Yes, sir.
Okay, that leads to the next question I have for you. You
So Jedi Jess, if I remember, and like I said, it's been a little bit since I've seen this testimony, I do believe they get into the fact that she actually owed child support in arrears, I believe, for the children that she had to terminate the rights to. So I believe she was still paying child support for her other children that she could no longer contact. And that being said, most moms will figure it out. You know, even if we have to go down to the food pantry, if we have to, get new school clothes at Goodwill, if we, oh, mommy's not going to have any dinner tonight, you guys go ahead and eat. That's what moms do. Monsters take out their anger and pain on an innocent young child. Shanda, which one are you? Let me give you a hint. Mom who's still human, monster.
Had monitors and cameras in your home, is that correct?
Yes, sir.
And the impression from the testimony I heard is that it was for the sole purpose of ensuring that Timothy could not get the food. Is that accurate?
No.
Why did you have all those monitors and cameras in your home?
When Timothy came to live with us, his stepmother informed me that they'd had motion sensors. They weren't as tech savvy as I was. I worked in tech before law school. I worked in tech support for several years.
She's Neo from the Matrix? Ew. She's like, I worked in tech support. You're probably the reason I couldn't figure out my damn computer.
But they had motion sensors and she told me that she didn't sleep at night. She only slept when he was at school because he was into everything. And so because my younger child, he used to, when he was about 2, he would take all his clothes off. So we started putting a camera in his room. And then once we moved to the...
Okay, the only thing in our lives that are similar is that my youngest, most feral, all the boys, look, there was a time period in my life where my mom would come over to my house and it would be a nudist colony of young little toddler boys, just me trying to fight, getting clothes on them. But I didn't put cameras in my room. Now, she does go on to explain that because her husband was in a wheelchair, it was easier for him to check because of the layout of the house, having cameras in the lower area where her youngest was. So he wouldn't have to go up and down stairs and maneuver that way. That being said, you don't put it. Her stories are so incredibly stupid and don't answer to a reasonable person why, you do these kind of things.
Marshall Road location, it was bi-level. My husband was born with a disability. My husband was wheelchair bound. So we had an extra wheelchair that we kept on the upper level. That's where the master bedroom was. But that way, if G was down in his bedroom, my husband could talk to him through the camera and have him come up. It was much easier. My husband could crawl down the steps before the stroke, but we didn't want him to have to crawl up and down those steps.
Okay. And
I don't pretend to be a Mensa member, and as a member of the cripple community now, I do have my cripple pass. I do. Why the hell would you buy a house with stairs when you have a husband that can't go up and down stairs? And I get logistically finding a ranch style house that has enough space is almost impossible. Mr. Mo and I are looking at, possibly building a barn dominium so everything can be on one level, because I'm essentially, limited to this level of my house unless I want to tackle stairs, and some days I just can't. What I fail to understand is that pants are prison. True. I would say rompers are a bigger prison. That being said, they are super cute, but they are a prison.
And again, let's go back to the issue of food. Was food the only reason why you felt you had to monitor Timothy, or were there other issues?
There were plenty of issues, sir.
So, well, first of all,
Not that I'm helping you because this is past you, but Shanda, maybe you would look less like a monstrous cunt if you didn't talk derisively about the son that you prolonged and torturously unalived. Maybe don't talk shit about the son that you killed. I know you're confused and you don't quite understand what you put off, but let me tell you from, a semi-hot mess mom, it kind of pisses us off.
The, what we've heard some testimony as to Timothy's special needs. What were his special needs?
He was on the autism spectrum, but he was completely verbal, and he was grade level in school. He was not behind in school at all. He was diagnosed with attention deficit hyperactivity disorder. He was diagnosed as bipolar and sensory processing disorder. I heard Paul mention physical disability. He didn't have any. Now, Timothy, when he first got there, said he had a physical disability, and I asked his stepmom about it to make sure, and she said no.
Hey, heifer, you're a learned person. Did you get his medical records? Because I have a feeling you're glossing over diagnoses. And if he did have, while it might not have been, an actual diagnoses, he would probably have been marked out for occupational therapy, fine motor skills, gross motor skills. So unless she has a detailed, medical history on him, I take nothing she says about his diagnoses. Notice how she was very quick, again, to highlight his intellect. Intellect is very important, in my opinion, to Shanda's identity. But anything else, it's derogatory. Everything she says about Timothy is going to have a negative or, derogatory slant. She and Sarah Boone could be soul sisters, except that they lack the key ingredient of souls.
He was not coordinated at all. The first summer that he lived with us, my youngest was playing baseball, and Timothy actually mentioned, because we had planned to put him in public high school, I'm going to try out for the baseball team, and I didn't say anything to him, but I remember thinking, sorry, sweetie, there's no way. You don't have the coordination for that.
She sure as shit said something to him. This woman couldn't wait to tear this child down and show that, in my opinion, again, this is speculation, the only child she was able to have a functional, if not very, very dependent relationship with, in my opinion, was her youngest. And I think she would do anything to demean and belittle Paul or Timothy in front of him. I think the only one that was spared the, evil that she visited upon her other children was Little Man. And I have no doubt she told Timothy in no uncertain terms exactly how unfit he was for baseball. What really gets to me is her cruelty, not the incompetence, not overwhelmed, cruel. Yeah, it's cruel. And this was her fun. That you can't tell me she didn't enjoy this. She thought of new and inventive and, Rube Goldberg ways to make his life miserable.
All right. And he liked to take, well, you tell me, did he like to take things apart?
Oh, yes, absolutely.
Can you give some examples?
He took batteries apart. He took toys apart, my youngest son's toys. If he could get a hold of anything from Paul's room, he would take, mostly it was Legos. Paul still had Legos. He, at one point, messed with our water heater.
What do you mean?
He actually turned the gas off to the water heater. He knocked out the pilot light and then turned the gas off as well at different points.
Okay. Did you have...
Shanda, again, hate to remind you, but as a mom tip, if you know that your highly functioning, very intelligent son enjoys the act of taking things apart and putting them back together, look, like I said, I'm a parent, I'm human, but you would offer him, activities where he could use his ability to take things apart and not cause damage. You would remind him of boundaries. You might not put him in a room or a closet next to your water heater. And you might feed them. But for someone so smart and who has access to Google, uh, just stop. She is so evil.
Any concerns as to whether or not his predilections, his desire to get into things might be a safety hazard for either him or somebody else in the home?
I was extremely concerned about that, yes, sir.
So it was your desire was it just your desire to monitor Timothy, or did you also have a younger child in the home that you wanted to monitor?
We had both.
Okay. Who did you want to monitor? One or the other, or both?
Both.
Okay. All right. So you set up these video and audio cameras, correct?
Yes, sir.
Okay. And alarms on the doors?
Those didn't get installed until about 3 weeks before he passed away.
Okay. And motion.
Again, Shanda, I need you to make this make sense. He could barely stand. He was not coordinated. He was barely leaving his room. But you want us to believe that you didn't put those on until 3 weeks before. Or did you destroy all the, film and videographic evidence that you installed them much late or much earlier? Because I'm going to guess it's the first one.
Sensors?
Yes, sir.
Okay.
He got around the motion sensors multiple times.
Were you able to stay home and personally monitor your children?
No, I had to work full time.
Okay. How were you able to get Timothy into school?
No, we were not. We tried to enroll him in Mona Shores High School, and Mona Shores told me that my ex, I guess Timothy had damaged a Chromebook in Oklahoma, and because my ex owed money on that, they would not send his records up.
Again, she's a lawyer. There are avenues you can go to get this done. You can, again, if she was struggling financially, if she had contacted that other school and explained the situation, generally there are ways that she could have qualified for assistance. So she could have gotten him into school, but then people would be able to see him, and mandated reporters are a thing. And this woman is cunning enough to know about mandated reporters. She's already lost 5 children at this point. She's not letting him out of her sight after she starts taking away food and, doing the stress poses. So I doubt she had any intention to get him into school, because if Timothy shows up, she has a whole new life in Michigan where she's billed herself as this, hardworking, wife and mom who's put herself through school and put herself through law school. And if Timothy shows up, people are going to ask questions like, hey, who is this child? Oh, they can look up the records, see that you aren't supposed to have this child. He breaks the new Shanda facade. In my opinion, I'm not a doctorologist. I do wish I could play Clarice on Silence of the Lamb, but look, I would have to do a jogging scene, and that just ain't going to happen. Jedi Jess says, also, this is a different excuse than earlier. Earlier, she said it was because she didn't have the documents showing she had legal custody. Yeah, the passive language is such an affront to reality. It's the same way that Lori kind of talks about how they were dominoes and, everyone knows the truth. That woman wouldn't know truth if it bit her on the behind.
To us. So we were not able to enroll him. So I found online homeschool curriculum that I had to monitor, but I enrolled him in that.
Let me make sure I understand. Was it your original intention to put Timothy into public schools?
Yes, sir. We started the process. I filled out the paperwork. Because of my work schedule, I couldn't actually take paperwork to Mona Shores. My husband did that. Adam did that. But yes, we did try to get him enrolled.
Okay, and the youngest child, G, was he in public schools?
No, he was homeschooled.
What about Paul? Do you know if he was homeschooled, or when he got to you, was he still in school?
No, he had graduated high school.
Okay. All right. Okay. Now, you mentioned that you weren't able to stay.
Sub Rosa says, by the way, what's with these women going all drill sergeant so often with the physical disciplining? Shanda, Jody, what's her face? I'm not a psychologist. I have 6 kids. I can tell you it's overwhelming, and, I've said things in the moment. I've yelled, I've screamed, I have fallen short of the, peaceful mom I've wanted to be. And maybe, this happened in her childhood, and instead of working her damnedest to try to break a, generational curse, she just went with it. I don't know. She's failing to use contraction in her speech. It indicates lying. I also think she's a very pedantic person. So, just kind of, I think she is very aware of choosing her words, and she wants to sound intelligent. So, the use of contractions can be more like a colloquial fashion of speaking. She is always attempting to show people just how smart she is, in my opinion. So she probably wouldn't use contractions. Uh, and you can tell when she gets flustered, she does kind of bring a little bit of her Southern back. But for the most part, she's very staccato. Yes, sir. Yes, sir. It and flat affect, except for her weird sort of facial twitches here. Not to mention, hey, lawyers, defense lawyers out there. Now, far be it from me to help people, help you, defend monsters. But everyone already hates this heifer. She comes up here looking like some woman from, Bergen-Belsen, or, one of the female guards at, Raven, like a female SS officer. Is as bad of optics as flippin' Amber Heard showing up dressed up as Ava Braun and Evita during the Johnny Depp Amber Heard case. I have never understood why these televised, trials don't have an optics person. That being said, I'm glad she did herself no favors. I am going to stop it here. We do have another line of pretty severe storms that are going to come through, and I need to do all the surgery things that Mr. Mo tells me about the computers. Let's see, what else? I I do want to go to Europe. I'm a big WW2 nerd, and I would love to go see the beaches at Normandy and a bunch of different things. But I also don't want to have to go to the DMV and get one of those real IDs. Because here's my thing, y'all, and this is my tangent, but I'm going to stand on my soapbox on this. Now, the government issued me an ID, and the government also issued me a marriage license. So why I have to prove to the government that I am in fact married to get this new damn ID, I will never know, because the government issued me the marriage. It's a principle thing and a lazy thing, to be honest with you. Because to be fair and to be very genuine, our local DMV office is really nice. They get you in fast and they're very sweet. So it's just the principle that y'all were the ones that done gave me the marriage license. Why do I have to prove to you that I got married when you've been taxing me as married? That being said, that's a Mo thing. It's just like, and Tammy, no, I do need to get it done. I just, don't feel like going in and getting it done. I'll make an appointment though. It needs to get done, and I need to be a grown-up adult, but it's still on principle. Y'all have all the files. I don't know why you're talking to me like I hold files. Have a wonderful day. I am sending you guys on to Tell Me Everything episode 5 with Rosalind Duke. So have a fun time with her. And remember, be kind to yourself, be kind to others. But have a sassy mouth and carry a can of bitch fire, because you might run into a Shanda in the wild. And don't nobody need that without curse words. Bye, you guys.